Yes, Mr. Cave.
Hello. Bearing in mind the time, I'm going to move on and jump around a bit. I'm sure that won't
Yes.
upset anybody. I hope it won't upset anybody. May I? It's in here. I wanted to pick up the discrete question of the prenuptial agreement.
Yes.
It's at page 284 of our unagreed bundle.
Sorry, what page?
284. It seemed to be a document or an agreement which the learned judge paid some store by.
It's the same, it's the one that's in, same as the one in the core bundle.
Yes, yes, I'm so sorry. It is.
Just if you don't mind,
Because it's
I'm
not into the core bundle.
4285.
Yes, thank you very
If you
much.
don't mind, Mr. Cave, I'm going to work from that because I'm
No,
not
please
stuck.
do, please do, please do. And I should have given you that reference anyway. Yes, Judge seemed to take a certain amount of interest in this. We say that this court should disregard the prenuptial agreement entirely for the purposes of these proceedings. Whether or not it's effective in Russia is not something that we're necessarily able to make submissions about. But so far as the UK court is concerned, we would suggest that you can't rely on it with any great degree of, in fact, you should just simply disregard it altogether. What we say about this is that it's essentially a declaration of property interests, property rights. We say that there's a lot about it that isn't helpful for the English courts. It describes itself, paragraph 1, of being a defining property rights and obligations. It provides also that it terminates upon divorce. It provides that
Where's that provision?
28656.
Yes. Are you saying that literally means what it says?
Well, I'm saying it's a good starting point, my lord.
So 1.1 is of no consequence at all.
Well, it is, and it may be that somebody would say that I don't know if somebody will say that the regime in Russia for for ancillary relief, as was known, is in some way different. In other words, whether or not a marriage cannot be dissolved properly unless there's financial provision made. But I don't think anybody can say that, because we all know that there is a divorce in Russia, which we've agreed is binding, and that there's an extant claim in England under Part 3. It provides that the 5.4, if the agreement may not be terminated unilaterally. That's fine. If one of the spouses disagrees with amendment or termination, the dispute should be heard under judicial proceedings under the requirements of effective laws of the Russian Federation. And we say that's inappropriate for this country. If one is going to transpose the provisions of this into what we understand and what you get from Granatino, and not knowing, there being no evidence as to whether or not this PNA would stand up in a Russian court, you'd have to look at it and say that there's no financial disclosure of any sort in here, not even basic, or any itemization of assets. Since then, of course, we know, had there been any itemization of assets or disclosure, there have been these very, very substantial dividends. And I'm going to come back to that a bit later on. There's no provision in this agreement for needs, income or capital, but relevantly the husband's needs. There's no provision for any capital dispositive element of any claim, that the parties belong to each party, but there's no provision within this for any transfer. In other words, it doesn't permit of the possibility that what are declared to be X's assets may be transferred to Y. It's simply silent on the point. And there's no question of any maintenance element in the order. And it's significant, we would say, that the judge had to introduce that element into his order. And he became creative and started talking about a usufruct. And in the end, as a result of representations and research done by Moylan and Friends team, came up with the provision that there should be this loan for use arrangement in Greece, which apparently is more satisfactory in Greece than a usufruct. But my point is that he got no help from the prenuptial agreement itself.
I should have asked this before, but you have a substantial skeleton argument, and on this sort of point, it's quite helpful to have what you and Mr. Tyzak have put in writing.
Yes.
To save writing things down.
Well, certainly.
There's very brief mention on page 70, paragraphs 75 and 76. Is there any more extensive argument about replacement, replacement agreement?
So, sorry, Robert, which paragraph are you looking at?
Page 70.
I think, in fact, sorry, it starts at page 41.
Oh, right. And that's,
Yes.
And goes over to page 43.
Yes, page 42.
thank you. That's very helpful.
The finding by the judge that it was all the husband's idea, that would have been contentious, and the husband doesn't accept that, but he wasn't there to give his case. His written evidence, on the other hand, was to the contrary.
Yeah,
And
could you
to
help
say-
with that? I managed to find in his Law Bundle 228, which my recollections is Form E, where he said that his understanding of the effect of this was that he would get nothing upon the termination of the marriage.
Yes.
Now, could you just tell me where else in the paper we find any evidence of his view? I mean, I know his view was that he was pushed into it, that he didn't agree to it, and it all came from the wife. understand that completely, and he says that in very brief terms in his Form E.
Yes.
But is there anything else that comes from the husband?
Well,
Yeah,
very
yeah.
much so, my lady.
Just give me the evidence. Give me the page references, would you?
Well, it's the same page, but paragraph 5.2 of the Form E, page 228.
Just give me a moment.
He says, the agreement says I'm to receive no financial remedy. This contract is a purely domestic document which is governed by the Russian family code. It's not expressed to have international effect. So he says, I never thought that would be effective outside Russia anyway. He also said he didn't take any legal advice, didn't have any opportunity to do so, nor did he get any financial disclosure. Then he says there was improper pressure, that's a subject, and he says there's some vitiating factors, such I don't invite.
And is that the totality of the evidence we've got? I mean, I know it encapsulates absolutely your case on
Yes.
this, but I just wondered if I needed to look elsewhere as well.
Page
271.
bundle call.
Supplementary bundle.
Lady, I'm very helpfully referred to 271 of the supplementary bundle.
Thank you. Thank you.
Yes.
It's most helpful, thank you.
I'm obliged to Moylan Junior, but that sets out his case. As much particularity as you'd ever given in evidence,
No,
I suspect.
that's excellent, thank you.
Thank you. And we say as a result of that, that on any view is unfair. I think Lordships may be aware of the various authorities on that. We've included one or two in our bundle, but restricted by the requirement to keep it short. IPECI is the one that we put in as being a very good example where of an American agreement was struck down by Mr. Justice Mostyn for various reasons, not all identical to this, but with certain number of similarities.
Sorry, which one are you taking us to?
IPECI.
Any idea what page number it is? The index is not, has no page
339 of,
references.
sorry, I don't know where that is. 339 of the authorities bundle.
Thank you.
I mean, it's an interesting case on its facts in the sense that there are some similarities.
bear in mind, Mr. Cayford, that although my lady and my Lord Justice Moylan and you and Ms. Stone know all these cases by heart, I don't. So you'll have to introduce them just a bit.
Most certainly. You will no doubt have come across the Fons Origins of Radmacher and
Yes.
Granatino and Lord Phillips's judgment, with which most of the Supreme Court agreed, but not all. And certainly Lady Hale didn't agree with the way he put his decision.
Yes.
And Lady Hale and the minority were very keen to emphasise that you could always strike down a prenuptial agreement if it was unfair. And you had to look at all the circumstances to see whether it was unfair or not. Without simplifying it, this has become a very fact-based jurisprudence. And this is, Epeki is an example of that, of where there was a very rich wife and a husband who was very much less so as a concierge of a London hotel. Reliance on the wife's resources made no provision for himself either by way of savings or pension. Family predominantly funded by the wife's resources. After 12 years of marriage broke down, husband applied for financial remedies. The trustee of one of the wife's trusts said the wife had no power or control over the trust assets, and that were she to give the trustees a direction to make payment, the trustees would have no power to do so. Also stated the wife was not the only beneficiary of the trust. So it's not quite the same, but in a way it's got resonance with the situation that we've got here with the wealth within the family. Sources Mostyn made a lump sum order to include a Duxbury Fund, Housing Fund, and a charge to the wife to recover some of it. He said that as far as the trust were concerned, the wife was solely and beneficially entitled to the substantial trust assets. So is there a parallel here? Well, arguably. On the balance of probabilities, the trustees would make those funds available to the wife for the purpose of satisfying a judgment against us. Well, again, Sir Jonathan Cohen has talked about the probability that the wife will receive substantial sums in the future, although he didn't tie it to a purpose of satisfying judgment. Obviously, on our proposition, bearing in mind all of the noise around this case, our proposition is that the wife should pay a lump sum to the husband that doesn't require any involvement from the family at all, and that the wife should stay with the family and she will be provided by them. But two, wholly unfair to hold the husband to the prenuptial no weight. Governed by New York law, defective, it didn't have a duly authenticated certificate that it conformed with the local law and its attestation. We don't know whether this is binding or not. We only know what people have said by way of hearsay. It would be unjust to attribute weight to the agreement under the law. The parties elected it would be afforded no weight. Well, that's the same point. The husband couldn't be said to have had a full appreciation of the implications of the agreement when he had no legal advice at all about the impact of New York law, and the agreement did not meet any of the needs of the husband. And then because the assets in that case derived from non-matrimonial resources, the financial application would be determined solely on a needs basis. The assessment of needs was a pure exercise of discretion. The width of discretion was not limitless, but it was wide, I'm sorry. And there it is, that's the similarity. The judge thought that was an agreement that he would strike down. Husband didn't realise the implications of this. Can't be said that this husband, in our submission, realised was aware that the implications of this may be that it would be argued to be effective in the UK courts. And you've seen his understanding about that. There's no evidence at all of any advice that was given. We know that there was a lawyer who, I think we all agree that it was a lawyer known to the family, known to the Rakshina family, who went to a room. She says not. Well, anyway, it doesn't matter whether it was.
It's in the transcript of 79.
Transcript. I'm referred yet again to the transcript bundle. Yes. Ms. Stone is asking her client, so it's a transcript page 79, bottom of page internal 45.
Can you just go above that? Did you know the notary in Moscow? Line 7.
Well, read the first part, but
It's like a different notary.
Sorry, what page again? Behind you.
79, my lord. I'm sorry, it's an awful lot to keep up with.
Yes, sorry. Which page on this?
Internal 45, but page 79, the bundle, top left. Miss Stone asks her client whether or not she knew the notary. The wife says no. Do you have a family notary? It's more a company notary, I'd say, or a family notary in Barnell. Sir Jonathan Cohen asks some questions, 2 in 1. Notary is a lawyer. We had my mum to travel with a child company, things would go to the same notary. Did you know that notary? Yes, for more than 20 years, I'd say. Well, it may be that she's saying she didn't know the one that appeared in front of them at the time, but she had a family notary. Don't let me take a bad point if that's if that's it. But whether it's the same firm again, it's not clear from this. But she says that, to be fair and transparent, she says at page 48, I haven't spoken to the notary before the meeting. We came to the notary, explained what we wanted both of us at the same time. And Lazarus Xanthopoulos is supposed to have said, whilst we're in Moscow, let's do it, and that's it. How long were we with the notary? 1 hour, more or less 1 hour. But not, the lady printed the document, she read it, she made amendments, it was minimum 1 hour. Read out the 2 of you, obligatory by law, any document you go to a notary, any document you sign. And then Sir Jonathan asked to be taken through it. The next page. Did the notary know the 2 of you were there in connection with a nuptial agreement? Which is a surprising question. If it were that it may presuppose that the notary didn't know what she was doing there. But anyway, I don't know really. I can't say for sure because there was no draft, so I don't know if she knew before or not. We're sitting in a room and discussing together what we wanted. So it certainly militates against the idea that there was any particularly personal advice given to either of them. And it goes through her evidence of the discussion. Lazarus said he wanted the agreement. I offered to pay him £1 million as settlement. He said, I don't need anything from you. $1 million, don't need anything from you. Nobody brought anything to the notary's office. Notary wanted to make sure that I'm actually capable of paying that sort of money. I confirmed that I could. Lazarus told me that. This is back in 2013, of course. At which time the wife had started to receive, she received the first of her dividend payments by then. So she clearly did have the money at that stage. And then there was a question. She said she didn't realise she wasn't planning in such a way to make me bring the documents with me. So even taking her evidence at its highest, assuming that Mr. Xanthopoulos was the one who initiated it, which, as you know from the document you've just read, he denies vigorously, says absolutely on the contrary. So there is the issue. Sir Jonathan heard the issue and found that he could believe the wife. So we're in difficulties on that. But what actually happened? Did this lawyer know what they were there for? Did she know anything about their personal circumstances? Did anybody produce any disclosure? Did anybody produce statements of assets, bank accounts, company interests, anything like that at all? The answer seems to be no. Did Mr. Xanthopoulos know what he was giving up? No.
Well, he did, because he says in his Form E he was giving up the right to anything upon divorce.
Well, I'm sorry.
So he did know what he was giving
Well,
up.
he knew he was giving up everything in Russia at that time. That's what he says. And that's another point that we'd make, that this agreement had no review clause. It had no provision for reconsideration. It had no provision for review in the event of further children arriving in the marriage. It was not something that was in any way tied to any particular asset. And we suggest in the strongest terms that in this country, a document like that with those provisions would not be upheld in this country as being too vague. You can't be sure that the parties knew exactly what the implications were. What was the husband supposed to think if the wife continued to earn a great deal of money, for example, as a result of things that were not known about at the time, or as a result of particularly successful trading activities, or something that happened in the United Kingdom, or anything like that? It's an absolute kaleidoscope of possibilities, of circumstances that could change between then and, well, in the event, 2023. So in the 13 years that passed, sorry, the 10 years that passed, all sorts of things could have happened and did happen. And if he genuinely thought, and if that's true, that it would be effective in Russia at best, but not anywhere else, and if the wife accepted that this should be an English claim under Part 3, governed by English law, then English law should govern the interpretation of this agreement. And the very best that the wife can do is point to it and say, well, that's what he thought he was getting in Russia. All right, not on the basis of any disclosure. I mean, it's not clear from this what the Russian law requires in terms of full disclosure, and the sort of process that happens in this country prior to the signing of a prenup, and how there has to be a period of time, a bit of cooling off, for example. There has to be, or the best practice is to provide written evidence of disclosure of assets, to have independent lawyers, each party having their own. So, so the effect of all of this is explained in a non-partisan way, and all those other provisions which apply, which I won't ask your lordships, your ladyships to take judicial notice, but I think it's fair to say that when one looks at the authorities and deals with it, one knows that there's a raft of hoops to go through to get a prenup into the condition that it is likely to be upheld by the English court. And even then, if a court finds that it's not fair, it'll discount it, it'll discard it. It has no complete discretion as to whether or not to uphold a prenup if it thinks it's unfair. And in this case, we say, as you know, that the overall order that was produced by the learned judge was very unfair, because it effectively gave the husband nothing. We've made the point in our skeleton, but let me just emphasize it. He's left, is he not, with a debt to his previous solicitors in circumstances where we tried to explain this morning that wasn't necessarily his fault, and it's not a reflection of litigation conduct or upsetting the solicitors or anything like that. There's no evidence to substantiate that proposition. It's an inference that one might draw, or that one could draw, but it would be unfair to do that, because there's the cost funding element to it, which could be a complete answer to any accusation of bad faith or disagreement between client and solicitor. So he's got a debt of £1 million or £500,000. He's got no lump sum at all, so no cash. He's got no property. And he's being invited to live in a flat in South Athens which was not a place that he ever suggested as being his principal residence. He certainly said it would be nice to have a £3 million or €3 million villa in Vula, and of course it would be, wouldn't it? But
Yes.
yes. And the pictures make it look very attractive, and we completely accept that. But it wasn't what this husband wanted to do by way of permanent occupation, permanent lifestyle.
Is his present position now that he wishes to live in London or Russia or Athens?
London,
Is his permanent home?
yes, that's something we have very much taken specific instructions on.
I thought you would have done, yes.
Yes, no, some of this has come as something of a surprise, but we've certainly asked some of the questions that have to be asked, and that's one of them. And he's very, very keen indeed, and very adamant that he would like to live in this country. And in a way, if I might, without losing the thread, it's why he was particularly disappointed when Sir Jonathan Cohen went off at a bit of a tangent, and I'm sure your lordships have read that. And in fact, it was his present solicitor's first involvement in the case, on a quick reading of the judgment, and a feeling that something should be done about this. That a request made to Sir Jonathan as to whether he would actually like to reconsider his capital usufruct sum, because €500,000, €600,000 isn't much use to buy anything in any way comparable in London, in a way that the photographs showed that it might be in Vula. And we know that the property particulars offered by Moylan Friends team at the trial showed properties in London at an average, I think, about £850,000. And so that was something that we, on his behalf, asked the judge to reconsider, because we submitted, and it's very much a submission of ours, that it's no business of the trial court in this country to tell litigants where they must live. And that single aspect of this order is in itself a reason to allow the appeal. We would respectfully submit that it really is extraordinary. And I'm not sure if anybody would disagree with me on received experience, but for a party, whoever it be, husband or wife, to be told that they have to live in a particular part of a particular country, in a flat that's not owned by them, in a flat that's owned by their former spouse, in a flat that they can change twice in its lifetime, once during the first 12 years of his occupation, and once thereafter, but on the basis that he won the concession that it shouldn't be for a period of time in any way contingent on the children. He won the for life point, which was a very small triumph in a sea of despondency, frankly. But it's quite extraordinary that he should be ordered to do that. I mean, what happens if he does get a job in London, for example? He must leave his flat in Vula and not go there. And if he doesn't go there, then it falls in under the terms of the agreement. If he doesn't need it, it's very bad jurisprudence. With great respect for Sir Jonathan, and he clearly worried about it, in the sense that when those instructing me wrote to him, he said yes, and I'm sure your lordships have seen it, so I won't turn it up if I don't need to. He said yes, he'd thought about that, and he minded to change the provision to a flat in London for £850,000. And Miss Stone made some more submissions opposing that, and again she was successful. And so we came back with the no, I've changed my mind. So it's €600,000 in Vula for you, and that obviously didn't appeal to the husband at all. So in a way, he was driven to this because his prospects thereafter, particularly when Jonathan said that what he had to do was get a job quite soon and probably in the property business, and the husband, if he gets a job in the property business, he certainly would like to think in terms of London, and again that's something that he's told us. In the event that this was successful, that would be the area that he would like to concentrate on. I mean, who knows what the property market in Vula is like? I mean, all we know is a lot of very nice looking flats all of which are for sale. I mean, what business opportunities are there in Vula? I don't know. Did the judge know? No, certainly not. But it's a very, very curious, therefore, to consign this husband to that particular part of that particular country, just because he's got relatives north of Athens, the other side of Athens even. It's not even as if it was close to his parents. And of course, he makes the point that if he wants to go to see his parents, he goes to Greece and sees his parents, and they live north of Athens, and Vula's south. His idea, in a perfect world, was to keep one of the London flats, one of the two Ennismore Gardens flats, and be able to buy a nice villa in Vula, which he thought, and he projected, was a reasonable outcome to this case, bearing in mind another aspect of the Section 25 factors that we've put into our skeleton, the party's lifestyle. It highlights, it really is stark to go from this, it's international whether Miss Rakshina likes it or not. It certainly is international. There's certainly toing and fro. We've certainly got the evidence of expensive holidays, and whilst Sir Jonathan talks about holidays mostly in Russia, there's a lot of evidence about holidays in the Maldives and other places like that. There's a lot of evidence about first-class flights. There's a lot of evidence of, even as the marriage was collapsing, they were apparently going on holiday to Greece by private jet from Barnwell for 25,000 euros, I think it was, that trip. But that's what they were doing, and it's the husband's evidence, and who can gainsay it, bearing in mind what we know about the income coming in and the expenditure, looking at bank statements and so forth, that isn't a fair projection of the way they lived. Ennismore Gardens, very nice. Barnwell, family house, fine. Holidays in Greece with his family and other places. He says they travel first class. She says not always. She has a habit of her hobby is jewellery collection. She agrees that she spent something like £1 million in places like Graf. Fine, absolutely no problem. She can afford it, and it's money that's come from her dividends. So there's no criticism of her, but it's just what is the criticism is denying and downplaying that when it comes to anteing up the available assets. And we say that there's a very clear pattern all the way through this case of her tactically dealing with situations, whether it's the petition in Russia, which I showed the court this morning, and what she said about the petition in Russia and what she said about where the parties lived, to this aspect of it, the financial aspect of it, downplaying the lifestyle, because obviously she'll know and she'll be advised by her good legal team, I should say, her excellent legal team, I'd say, that lifestyle is one of the relevant factors, and if the parties had enjoyed a very good lifestyle, well, then that may well reflect in an order. And it's disappointing that Sir Jonathan accepted the submissions, or appears to have accepted the submissions, that this lifestyle wasn't the glittering jet-set lifestyle that the husband, for what it's worth, says they enjoyed. I mean, the court may say, well, how can you guarantee that your client isn't doing exactly the same thing? And I can't, but that's his evidence, and that's evidence that permeates the papers, and it hasn't been materially rejected, it hasn't been seriously contradicted, that was how they lived their lives. And they have staff, obviously, staff in this country, staff in Russia, a lot of company expenditure, a lot of the wife's expenses against her relatively modest, it said, salary paid for by the company. And nothing wrong with this, but exactly what you'd expect of an international, very wealthy family. And by very wealthy, I mean the wider picture. She's a 25% member of a group of companies, which one expert says is worth $350 odd million, and another one says it's worth $400 and something million, and which I think the wife herself accepted 350 million figure. So it puts her interest, subject to the arguments we had this morning, something not far short of £100 million. Well, there's wealth, and you have to be doing very badly within a family like that when you own 25% of the shareholding to find that the grocery bill isn't paid, or that money can't be found to satisfy a financial remedies claim. And if that can bring me,
Sorry, just where you're dealing with standard of living,
yes,
we have the Form Es in the core bundle.
yes,
And I can see that your client produced, I think, a schedule of future rather than historic expenses. I might have missed historic. For page 231.
yes, my lord, yes.
In other words, where's the... Is there a schedule that he set out, his estimate of the family kind of expenditure, or not? And we have the wife's schedule, I think at page 338.
Yes. Yes.
And that sets out, I haven't gone to look at all of the individual items, but the total is about 23,500 pounds a month.
Yes. So, and that fits with what she said elsewhere of about I calculated about 300,000 a year expenditure. And she's got current, she's got anticipated. Interestingly, just so we're all aware, she says anticipated London, nothing apart from that housing. So for what it's worth, it seems fairly clear that she's effectively abandoned or said goodbye to London. So if one's talking about the need for the Ennismore Gardens flat,
Well, yes, that,
maybe a leap slightly further than you were inviting me to go.
that's just like, because we know that the daughter is here.
She is.
And I was trying to find out, I was trying to look, and I might have missed it, where the expenses of maintaining her here appear on this schedule.
On the wife's schedule.
Yes.
Well, I don't know. It's not
There's something
ours.
on page 348, expenses specific to children.
Yes, well, that's that's a reasonable start. 10,000.
Couldn't see anything on that for the person who is looking after her, but maybe I've missed that.
The nanny or the carer.
Yes.
No, I don't suppose it's the personal trainer, is it?
This was before.
Anyway, so that anticipated expenditure for the children, I think it is both.
It's children in that schedule. Lord,
Yes, it is.
It's in the middle of that page.
Is it?
Lord, I don't want to interrupt, but page 348, the page you were looking at,
Yes.
it's in the middle of the London column, nanny, au pair, mother's help. The company pays her salary as part of my client's remuneration.
Sorry, wait a minute.
It's
So
the,
is
the
it
wide column.
Oh yes. The big gap on the left.
Sorry, wide row, I should say, not wide column.
Halfway down that schedule.
Page 348,
I'm on
the
page
core bundle.
348. Clearly need glasses.
There's one wide column, one wide row.
It's the row without any writing in it, my lord.
You can
Yes.
see that bit
Oh,
without
I see.
glasses.
I've got it. Sorry. Thank you. Yes. So there's what is that? 2.5? No, wait a minute.
2,500 a month.
2.5 a month. Okay, I understand. And that total, that is not included in the total at the bottom.
Yes, it is.
The 2.5 is.
Yes, isn't it?
Is it?
Isn't it?
Don't think it is.
No.
Can't be.
No, it's included in her remuneration. Yes, it's included as part of her remuneration package, but not as,
Not as an
Not on this
expect,
total,
because
no.
this is an expenditure total,
Yeah.
not an income
Yeah.
total. Yeah.
It's not here. She's told us about some of the corporate benefits she gets, including travel and cars and chauffeurs and so forth. It's exactly as we would expect. And again, there's no complaint or criticism of that. Whether it means that Ennismore Gardens isn't available for the husband's reoccupation may be another question. It's certainly within this court's power to make a property adjustment order in respect of that property, and obviously if that were the case, either the 17-year-old lives with father, he'd love, or
Given they're not speaking to each other, I think
well, no,
that
they're
would
not.
be.
No. There's a sad estrangement. It's
And that's awful. I mean,
Yeah.
you know, that's one of the worst things that come from this litigation, that the family have spent over £9 million, and what's happened is it's been completely destroyed.
completely, utterly, and entirely. And I know what my instructions are, and I'm sure my friend's got different instructions. But we can both say, I'm sure without fear of contradiction, that is very disappointing indeed. And any attempts that anybody were able to make to resolve that situation would be a good thing. It's a situation we come across all too often.
Mr. Cayford, are you going to go back to the post-nuptial agreement, or have you
Lord, I'm very happy to, yes.
Well, I have a question. It may reflect my lack of experience of the subject. Suppose that we find we can't interfere with the judge's finding that the agreement was freely entered into. Ranmacher and Granatino, the regime isn't all or nothing, is it?
No.
I mean, suppose that the agreement was freely entered into, possibly it was his idea, he knew the notary and so on, but the result is, if you enforced it to the letter, it would not provide for his reasonable needs. Doesn't mean to say that the court ignores it altogether, does it? It's a factor to be borne in mind.
Exactly.
Thank you.
Exactly. And the court, as I say, I was speaking in slight shorthand when I said that effectively it remains a discretionary exercise.
Yeah.
But to get there, you have to go through the hoop that Your Lordship just put yourself through. In other words, we say that this was freely entered into, and we're looking at the net effect and the consequences of this. Are we happy with that? Do we think that's fair?
Yeah.
Actually, it was freely entered into, but no, this is very unfair because of whatever reason. And Radmacher certainly makes that clear, even in the stentorian judgment of Lord Phillips. But if one were to look at the other judgments, including that of Lady Hale, she makes very clear she thinks that there should be residual discretion. And the cases that have come since, and we've put in one, and I think Moylan Friends got another one. There are lots and lots of cases about it's an issue that crops up the whole time. And I hope I would not be contradicted if I say that the court must look at all the circumstances to decide whether or not it, in its discretion, wants to make the order that is being sought or being contended for. And it's because ultimately the court is the arbitrator, is the decision maker.
Yeah.
And that's the big difference between a commercial restrictive covenant, for example, or pre-contract agreement, which would be enforced under the strict letter of the law. But the English court retains its discretion to make the order comes from the court, not from the parties' agreement.
Yeah. Well, I thought that was the case. I mean, you using the language of striking down or and so on. It isn't really that, is it?
Well, I shouldn't have used the word striking down if I did. But disregarded or avoided or ignored or upheld.
But I think one was also saying that there's effectively a middle ground which can be, yes, that was something they wanted. That's what age 32 he felt was fair, and he was signed on the dotted line in accordance really with the judge's findings. However, where we are now at the end of the marriage in 2023, that doesn't adequately meet his needs, and so it has to be revisited.
Yes.
Whilst bearing in mind that he did enter into something along those lines originally.
Yes, if one accepts the judge's logic about that and his finding about that, that's exactly where we are. To which I would say, apart from anything else, that was 10 years ago, and as life evolves and as parties age and as their expectations and circumstances may change, as the parties' lifestyle between the time of the prenup and the adjudication in court changes, all of that has to feed into the Section 25 exercise that the court carries out.
Thank you.
And the party's lifestyle, which is a Section 25 factor, is also relevant there, because it may be that in 2012 the parties weren't living quite so high on the hog as they have been since, by reason of the very considerable earnings that the wife's been able to achieve through her dividends and the lifestyle that's evolved and changed. And if that's the case, the court is obliged at least to bear in mind the lifestyle of the last 10 years that may have been different from what they were doing when they were students. Well, I mean, they weren't students then, but it was much closer to the beginning of the marriage and the student meeting and student accommodation and student friends and that kind of thing. So, this court, in our respectful submission, would have to either, if it were with us on the unfairness of the agreement, on the unfairness of the agreement, and be inclined to do something about it, it could either decide that the weight to be given to it would be very much less than that which Sir Jonathan gave it, and the consequence is this. It's not easy. It's a difficult exercise, particularly for an appellate court. I understand that. Or it may say, well, send it back downstairs for a reconsideration. I mean, on that point, lady, you're aware of the rules that suggest that open office should be made at a fairly early stage in these proceedings, and that's come out of long experience and bitter experience in so many cases. And we have to accept that we haven't been great on that particular point. We have at last made an offer. We've had no response, so I'm assuming that it's not something that's going to lead to a shortening of this appeal.
Given that it arrived yesterday, it's hardly
Yeah,
surprising.
well, exactly. Exactly. I know.
You're a master of understatement, Mr. Cohen, saying it was not made early in the proceedings.
No, well, I wouldn't want to over-embellish my points, my lord, but it
Perhaps
was...
wasn't couched in conciliatory terms, shall we put it like that?
No, that is also true, and in some senses, well, I shouldn't say it, but anyway, that probably wasn't necessarily straight from the precedent book. But as you understand, lady, the passions run high in this case.
I do understand that.
And have been so aggravated by the children issue, as I'm sure you'll understand. What I can say about some other aspect of this that occurs to me as I speak is that you will have noticed that although Mrs. Xanthopoulos was clearly in a bad way in last year and up until the spring of this year, we've not sought to adduce any further medical evidence, and that I hope you'll see as a good thing. Obviously, if we were preparing a case tactically, we'd probably look to get an updating report from the consultant psychiatrist to confirm that he's unemployable and at rock bottom. But we haven't done that, and living a slightly quieter life and slightly less argument around, albeit not of his making, not as he would wish to leave the children. He's feeling a bit better, and he's taking his medicaments, and he's hoping that the bad patch last year, the very bad patch last year, that culminated in the attempt and ran through until the early summer of this year. He's hoping that that's something slightly in the past. And that's not a medical observation or prognosis, but you may well have wondered why we hadn't applied for yet another report on his medical condition. And obviously it's something we discussed, and he's optimistic that as things progress, and yeah, we made a point. It's on that point. He made a point in his evidence, and I think probably in some submissions as well, that he's very reluctant to disclose his full medical condition in these proceedings, because he was terrified of their being used against him in Russia in the children proceedings. And without going off piste or delving too deeply into matters that don't specifically concern financial remedies, you can understand his concern that were he to offer a hostage fortune in that way, by describing quite how badly he felt on bad days, this may not help his Children Act proceedings in Russia and his attempts to regain contact with his children. I pass it on for what it's worth. It's in the bundle.
Okay, picking up what you were just saying about the, and I appreciate this is only one aspect of your submissions, but you're saying this court, as obviously does, has two choices. One is to send back for rehearing, and the other to make an order itself.
Yes.
And there's obviously you're challenging the level and the form of the provisions made by the judge below.
Yes.
And you put forward, or your clients put forward an offer recently. There's obviously some distance between the level of the order made by the judge and what is sought in the most recent offer. What's your client's position in respect of something that might be in between? I mean, what's your client's position in respect of his potential debts to his solicitors and other debts?
He is very mindful of the situation that he's in, that we're all in. He's very mindful of the headlines about the costs of this case. He's very mindful of the fact that he is portrayed as being the person responsible, and certainly was by or before Sir Jonathan Cohen. But and it's obviously something that we've pursued with him at some length, because it's a very, very real question. And I wanted to, well, I can say that he would be delighted to get rid of this case, have it all closed down today, tomorrow. He's got no inherent enjoyment of litigation. He feels there's been a great wrong done to him, and he's been pursuing that particular concept. But in terms of settling, of finishing the case, by making the offer that we have done and expressing it in terms of being a clean break, we're very alive to the possibility that a slightly lower figure might be considered to be more appropriate. I'm not in a position to put, as it were, negotiated figures to you. But he is very interested in the outcome of this case. And one of our other points was that the judge wholly failed to create a Section 25A result, because the form of the order, as you know, is as we say, is shocking, really, in the sense that he's beholden to his wife forever, for life.
Not unheard of, Mr. Cayford, at all.
It's not unheard of, but it's a lot worse when the parties are such loggerheads with each other and they're trying to repair the relationship for the sake of the children. It's not unheard of course. It's one of the collateral damage aspects of this kind of work. I agree. but in a way, he's got, if he's making an offer, he's got to make an offer, well, he's got to make an offer which his wife would accept. Alternatively, one that might resonate with the court in due course, if it has to be relitigated all over again, or which, I think the last time I was in front of Lord Justice Moylan, I think we had a discussion about finishing the case on the basis of the court making an order that was the right order, and the court acceded to that submission. And so the court did make an order that, that dealt with the situation pragmatically. And indeed, in your judgment, you said that that was a pragmatic approach which commended itself to the court. So we're aware of that.
Is that what you're asking this court to do in the event that you succeeded in all or in part of on your appeal?
Lady, I hope so. As of right now, I can't say that, because as of right now, you haven't heard all the argument, you haven't made a decision,
Understood.
and I haven't got specific instructions to accept a particular offer or to put Mr. Xanthopoulos' life in your hands to that extent. I mean, I hope I can, because it would be my submission anyway, the best way out of this if the right figure was arrived at. But then again, Sir Jonathan's idea of the right figure is so far away from what we consider to be the right figure that obviously Mr. Xanthopoulos is a bit nervous at this stage. But in principle, he would be delighted to have done with this litigation in this court. And
But it's open to us to do that, isn't it?
yes,
And if we think that the judge's order was wrong, we're not bound to say, well, the whole thing will have to start again. We can't possibly express a view.
no, of course. No, Lord, I entirely agree, and that's what I'm suggested it in our note, in our skeleton, that the court's got these two options. I'm only being a little bit cautious because I would need specific instructions, and you'll gather that by reason of the offer only being made yesterday.
But even if you didn't have specific instructions, do we
That's
have to have the consent of both parties to
No, you don't.
reach a decision ourselves?
Of course not. Of course not. No, but sometimes situation might be that if a litigant is successful and his case hasn't been heard fairly or properly, sometimes the court's very happy to send it back down for a proper
Yeah.
hearing, and that happens a lot even in this division.
Yes, I understand that. Speaking for myself, the idea that this financial litigation should start again fills me with dread.
Well,
I don't know what Miss Stone's views or instructions will be on it, but given the time and expense it's taken to get here, I've said enough.
Lord, if I can politely simply agree, it was I think what we said in the very first paragraph of the first skeleton that we did for the permission appeal. This is all shocking and it shouldn't be allowed, and it's a failure on everybody's part, frankly. It happens. That's why I suggested earlier on that this court may want to say something about costs. I mean, it's a very hot topic at the bar at the moment, as you will understand. And there's a lot of words spilled and not necessarily results achieved. And it may not be the right venue to do that anyway. But I would not seek to argue, and I wouldn't even take instructions to argue that this has been the right use of money and the right use of court resources. And one looks at it, even at the time, but from the perspective that I have of coming into it, I think I'm the most recent person into the case. I look at it possibly rather more like your lordship does. You know, what is this? How has this been allowed to happen? Shocking. Shocking. And my client knows my views about this. So I'm making
All right, but I'm
submissions on
afraid
his-
we slightly diverted you from your course. I can't remember what point you were on. Maybe you can't either.
Just
but,
finish lifestyle.
Yeah, lifestyle. Right.
lifestyle. Yes, I can't. Well, let me look at my chronology.
Certainly, if you want to have a word with Mr. Tyzack, then do.
Well, Lord, one thing we thought we might actually do is let Mr. Tyzack speak to his schedule, in the sense that he's got a very clear view of the permitted schedule, to assist your lordship with some of the transactions that took place.
We said we would allow in number 4, the dividend income, and
Yes.
I think you've covered that.
Yes.
Number 3 was the one with great sympathy for to Mr. Tyzack for the midnight oil that has been burned to no avail. We were not prepared to be addressed on.
I'm not seeking to argue against that. I mean, it's the only shame is that that's all evidence that's been put into the case already. It's just that if you were interested at all, and maybe you're not. I mean, maybe I've said enough. I don't know. But if you were interested at all in the levels of disclosure and frankness between the parties in this case up until now, he's got things that he could very usefully say to the court.
In number 1, yes.
And then we've got the material we can go to whom?
Yes. My lady points out to me that most, if not all, of these points are made in the blue version of the quote chronology, and we have agreed to let that one in. Just a minute. I think the best thing is we'll take a 5-minute break. You speak to Mr. Tyzack and then tell us what points there are still to be made. Don't feel that you have to keep speaking till 3:45 just because that was the time we mentioned, but sometimes a 5-minute discussion enables one to make things concise.
Just to be clear, I think we're all clear in our minds, I think, that part of your case is that there are potentially undisclosed assets which had the husband attended. He would have cross-examined about where money came and went and how it moved around. So I think we have that in mind.
Well, I'm very much obliged. That might
So I
help
don't
me
know
in
if
my
that-
might help me in my discussions.
Right.
You and me. Yeah, I want the reference to the. I wrote down right now. Yeah. There you go, 5 minutes.
maybe it's water, different water. It's dry. It's dry to me. Different water, I have one tried one before. I have eaten all.
Okay. Yeah. You are going to do it.
That's what confused me.
Are you intending to address them on this?
On what?
Are you intending to address them on this?
On the schedule?
Yes.
The one that he's
Yeah.
ruled out?
Yeah.
No. So what was it, Will? It's the... I wrote it down, I'm so sorry. HB.
SB.
SB.
Yeah.
Those two.
Sorry, 18 what actually? Are we ready?
Yes, Mr. Kent.
Lord Thank you. Can I pick up on what we had been talking about? I'm not going to address you on the schedule, incidentally, if that's
Good.
a reassurance to, to everyone. I won't do that. But what I would just draw to your attention, it's going back on it's the offer, it's the position that the parties took during the course of these proceedings, and it's instructive in our submission. And this is paragraph 52 of my skeleton. Our skeleton, I'm so sorry. It's instructed May 21, the wife made an open offer of the transfer to the husband of 29 Ennismore Gardens flat, which was believed at the time to be worth in excess of £7 million. That offer was initially expressed to be in settlement of the husband's claims, modified 6 days later to be on account of those claims, and then adding a further condition that it be subject to a licence to occupy by wife and the children. And I say, whilst the husband might now be rowing his decision not to accept that offer, that's post Sir Jonathan Cohen's decision. It was made at a time when the jurisdiction dispute remained unsolved, and thus it was not known whether the husband's application would be dealt with pursuant to the MCA or Part 3. B, it was before the disclosure process had taken place. C, it was made against the background of the party's lifestyle, which the husband contends was considerably more than very comfortable, as Sir Jonathan put it, and on which I've already addressed you. D, it was made before any suggestion or judicial findings had been made that the wife's substantial shareholding in Maria Ra was not hers in equity and fact. Had the court accepted the husband's case as to the wife's net assets and concluded that her net wealth was in excess of £100 million, an outcome of £6 million to the husband would not have been excessive, rather it would have been extremely modest. Pending proper disclosure from the wife, the husband was therefore unable to evaluate the merits of the offer of the 14th of May 2021. So his failure to accept or counter-propose is to a large extent vindicated by the lack of disclosure. And your lordships will know that it wasn't until March of this year that the dividend schedule was capable of being created, because the dividends hadn't been declared, disclosed until then. So that new disclosure.
Sorry, not at all.
Sorry?
Sorry, they didn't know that. I'd missed that. So it was only in when?
With Evgeny, her brother's evidence in the trial.
And that was the first time you knew about the dividends?
Yes. Or the extent of them.
So the brother, just so I've got that right, so the brother's evidence in March of this year was the first time the husband's team knew about the existence of the dividends?
That's correct, isn't it? Yes. 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 Sorry, I'm slightly misleading the court inadvertently. The first 2 years, the 5 million and the 3 million were referred to in previous documentation, but the subsequent payments were not known until.
And then there's a dip to 46,000, and then
That's
there's the final year of £1 million.
Then there's the 1 million, and then there's the 7 million, which disappeared from the schedule.
All right.
But the point I'm making is a fairly obvious point. But it's that an offer like that has to be seen against the background of full disclosure, and it's certainly taken them quite some time to get to the point where a proper assessment of the assets in the case had been very hard to make by reason of what we would suggest would be a certain amount of non or late disclosure. Lords, paragraph 53 of our skeleton, we put the converse position. The wife will presumably have known at the time of her offer, that's 2021, that her case was going to be that she didn't own the shareholding, and that her net asset position was broadly as described by the judge. In that case, the offer of 6 million or 7 million on account of the husband's claim against an asset pot of that 6 million plus the balance of the Coots cash at the time, say £10 million in round terms by that stage, i.e. a total of 16 million plus the jewellery, would have represented a reasonable starting point, but not so good an offer that the husband would have been unwise not to accept it. But he would have been entitled to think about this against the background of his own projection as to what would be a fair offer. And if she was going to be saying that there are only £16 million in total, and you might have said something else about the house being needed for the daughter or whatever, then that offer is probably rather more than one would have expected, bearing in mind where they'd got to with their respective disclosure or analyses. It was accepted. If you would kindly turn to Supplemental Bundle 286. Actually, 287, if you just go over the page, I'm so sorry, the very top of 287. This is the offer. 29 Ennismore Gardens was funded by money advanced by our client's family. Well, that's maybe that's an issue, but this sentence, whilst we accept as the matrimonial home, it's likely to be subject to sharing. The entire purchase price is non-matrimonial, and that will impact on your client's overall claim. And we say, with respect, it's important to bear in mind or to note that the wife's team at the time accepted that Ennismore Gardens was a matrimonial home where the parties had lived for some years, and not really the point that they're, or the tack they're taking now. Not really consistent with the suggestions that actually they were a Russian family. And indeed, if I anticipate Learned Friend's submissions correctly, she may repeat what she said before, which is that being a Part 3 claim, you have to look very carefully at the parties' habitual residence and the circumstances of their domesticity. But this is from the horse's mouth, and this accords entirely with what we've been saying, that the family came to this country in 2016, and had the marriage not collapsed for whatever reason, then that would have continued to be the matrimonial home. Both children would have carried on being educated in this country, and they would have continued to live the hard working, and I'm not in any way disputing the hard work that the wife must put in, and commuting to Western Siberia can't be exactly easy. And if she was doing it every fortnight, which is what she says, then again she deserves credit for that. It's an impressive and grueling business, but that doesn't absolve her from not, as it were, trying to cut a few corners and make a few assertions as part of her case that really don't stand up. And then when from time to time, in a sense, she's caught out, or her solicitors say something on her behalf that isn't really in accordance with what she's now submitting, the court's entitled to have a look at that and be interested in it. Down the page, she is saying that in an effort to bring an end to this waste of family resources, here are the following proposals, and to the usual proper provisos. She says her clients had some financial support from her family, but it has limits. Came from nothing, have worked extremely hard. They do not live the lives of the super rich, nor have our respective clients. Well, it's a bit of an issue, but it may not inform this court over much. But anyway, there's the offer. She's prepared to transfer the house in its entirety. She wants her divorce in Russia, discontinue the suit here, support the children on her own income, take responsibility for their educational costs. £7 million. So that's what she was saying at the time, and it's worth comparing that with the outcome that the husband finally achieved in front of Sir Jonathan Cohen. It can't be said that £7 million have been spent between that date and the date of the Cohen hearing. We're not quite anyway. But that's something which, in perspective, is interesting. Would your lordships kindly look at the husband's bundle, an agreed bundle, page 800.
There's one on that one.
First page of that. This is the only time I'm going to do this. There's a big argument, but I'm sure your lordships and your lordship have got the point that there's mistrust between the parties as to what they disclosed and what they didn't disclose, and when they did and when they didn't. And we could go on, I'm sure Frank could go on as well, at some length about this, but the point only needs to be made once, and it doesn't necessarily deal with the future. But just so that we're looking at this, 12th of May, this is from the wife's solicitors to the husband's then solicitor, paragraph 3. In terms of income, I attach a schedule showing my client's income from 2015 through to 2020. 2020 shows the highest income, but even then the total in 6 years was less than 1 million. 2020 was higher because Allah had taken greater responsibility within the family business. Been trapped in this jurisdiction since October, can't carry out the responsibilities expecting of her, and income will reduce this year as she won't receive any dividends bonuses. And he says that she had £1.7 million when her statement was completed. He says, and he refers to a schedule, which is at page 803. And it, put bluntly, fails to disclose any dividend received in 2016. Which we know was significant. And I just draw your lordship's and ladyship's attention to that, because that is an example of where not the full picture is being given.
Right.
Lord, I turn then back finally to my skeleton,
Yes.
which I dare say your lordships have read sufficiently carefully as you felt appropriate. I've made the point about the offer and why the husband didn't accept it.
Yes.
Well, we've got a very short submission at paragraph 2 about the award being discriminatory. I don't think I can, as it were, enlarge on that. It is what it is. It may be that you maybe you can see the point, but I'm not going to labour it and I'm not going to repeat it. You see the point that if a wife ended a marriage in these circumstances, with a husband telling her she had to live in Turkey or America or anywhere, somewhere, when she was saying, actually, I don't want to do that, there would be cries of anguish, and frankly, the family bar would not believe that such an order could or would be made. It's very, very unusual in our respectful submission, and it's aggravated by the insult, if you like, of the husband not being entitled or trusted to buy his own furniture. So the wife's got to pay for the furniture.
Well, anyhow, apart from the label discriminatory,
Yes.
it conveniently puts in one place the 6 subheadings of why you say that the award was inadequate.
Yes, exactly. I'm very much obliged. Section 3 was section 25, and I hope I've dealt with the various Section 25 factors.
Yes.
And we spell it out. Number 4 was the housing needs, and I think I've probably dealt with that, hopefully, and we say that it was unjust and inadequate. I've referred to Sir Jonathan's flip-flopping about in May, and I emphasised the mischief in specifying where he's to live against the background that the judge says that he should seek employment in the relatively near future. I mean, there's no evidence of work available. I dare say he could get a job as a barman or something, but if he's to make something of himself, can he do that in Vula? I don't know. Can he travel from Vula to Belgium or to Frankfurt or to London? Well, not easy with that amount of income.
But your client's case, as I understand it from what you've told us today, is that he wants to live in London. He wants to establish himself in dealing with property in
Yes.
some description, relying on the experience and contacts that are set out in those parts of the papers we've got where he's
Yes.
been up to, what he's done.
Lady, spot on. I'm very much obliged. I won't need to trouble you any further about that. I've dealt paragraph 79 with the longer term maintenance. The level of expenditure. I mean, bear in mind where the parties have come from. The offer or the provision made by Sir Jonathan is startling, actually. And although some people can possibly survive on that much, our evidence is that they spent about that much, the annual figure per month, on their lives together during the latter part of the marriage. But anyway, there's a repetition. The sharing principle and computation, I mentioned that earlier on. I hope I got my point on that, which is that, however you look at it, the money that came into this family, that you can see a little bit from the schedule you did permit into evidence, has effectively come from a shareholding. It's too simplistic to say that shareholding came from her father, therefore it has to be totally excluded from the equation. And not only that, whilst she says conveniently that it was a gift and therefore it should be excluded, she's had to work for that. She's had to work very hard for that, and she's obviously a valuable member of the team. They all accept that. Her brother accepts that, amongst his other rather more chauvinistic comments about women in the workplace. He accepts that she's a hard worker and that she's a valuable member of the team, and that when this is all over, she can expect some decent remuneration. So that you have to take that into account in our submission. And what she's got now, and what she's built up, without going into prohibited territory, she's built up by reason of her basically her hard work. If she didn't do that, then you can be pretty sure that she's unlikely to have either kept the shareholding or to have received dividend income at the rate that she has.
Really, when the ex-wife has got the 25% and gets the dividend and also has to hand it back?
Well, it's total speculation, and you may be right. I mean, I don't know, but what we are submitting is that as the package that she offers the family, she's offering not just family membership and loyalty and understanding. She's also offering the position of FCO, which she's held for the last 15 years, and clearly does it well, and to the point that when she's travelling across Siberia every 2 weeks, this is not to party. This is to work very hard in what is clearly a massive family business.
Where's the evidence about that? I'm very sorry, but my learned friend is making submissions which don't appear in the evidence anywhere. Travelling across Siberia every 2 weeks.
All right. Well, you've been very patient, Miss Stone, but let Mr. Cayford finish, and then you can tell us why this is a bad point, if it is. Carry on.
My Lord, the reason I said that is because the evidence from her and her own statement was that she was commuting to Siberia on a 2-weekly basis while she was coming back to the children in this country, and the husband was looking after the children for the 2 weeks when she wasn't here. And then during holidays, they go out there. That's where it comes from. It comes from her own evidence. contribution, I think I've probably dealt with.
Yes.
And it's here. The section 25A point, I've referred to it in passing. I hope the Lordships think that I've made it adequately. It would be might be a recipe for absolute disaster to have this wife controlling this husband as to whether a property is suitable, as to whether he can have a blue chair or a red chair. I don't know, I'm making it up, but again, one can see the scope for disaster is pretty huge. And frankly, it's not as if she can't afford to buy to pay for some furniture for a property, whether it's in London or in Greece. So the idea that it has to be, as it were, controlled or paid for by her is insulting, and it's demeaning, and it shouldn't be upheld in our respectful submission. I've dealt with I hope I've dealt with the Radmack point.
Yes, you have.
One of our authorities was Brack, which of course my lady Justice King knows all about, because she decided it. But
I may have decided it, but it's a while ago, so
well, let me remind you, Ladyship.
I'll reread it.
Paragraph 97 of our skeleton sets out what we thought maybe the kernel of what we were talking about before. Common ground in financial remedy proceedings where a judge has found there to be no vitiating features in relation to the prenup. That was Lord Justice Bean's proposition. He's entitled to applying the Section 25 factors in his search for a fair outcome to take into account needs, compensation and sharing. In other words, the fact of a valid prenuptial agreement does not necessarily, brackets, but may lead inexorably to a solely needs-based outcome. And it's the may. It doesn't have to, but it may. Might be persuasive, depends. And then there's the expert valuation report, which Lordships have already dealt with, to our disappointment. Lords, is there anything else I can help you with?
Thank you very much, Mr. Cayford. We're very grateful to you.
I'm obliged.
Mr. Tyzack? Miss Day?
My lord, my lady, there are, I think, 7 matters with which I want to deal. And if I can just outline to you what those are going to be,
Yes.
and then you'll know, I hope, where I'm going. The first is medical matters. The second is the injunction proceedings, about which you have heard nothing. The third is the postnuptial agreement. The fourth is my client's interest in the companies. The fifth, albeit briefly, is going to be about allegations against my client. The sixth is going to be housing in Greece. And the seventh is going to be fairness.
Right.
And there is overlap between these matters, so I hope you will forgive me if I take a little time over some of them. It is difficult, having sat through these proceedings with my client, to hear my learned friend address you fulsomely about his client's case. Because one of the things that you will have picked up, I hope, is that from the summer of 2022, he did not participate in these proceedings, save to the extent that it suited him to do so, and where he saw it to be to his advantage. And so when Sir Jonathan Cohen listed that he had been in breach of so many orders, that included the failure to file a Section 25 statement, in other words, to set out his case, the failure to reply to a schedule of deficiencies, which he was ordered to reply to, the failure to provide any property particulars to tell the court where he wanted to live. And the fact that it was the summer of 2022 is highly relevant because at the beginning of the summer of 2022, he participated in a very fulsome way in an application which pushed the substantive hearing out of the list, where he was alleging that the property next door to the Ennismore Garden flat, which was registered in my client's name, and which had been purchased in her name at the beginning of September 2020, belonged beneficially to her. And we had a 6-day hearing about it, in which my client gave evidence, the husband gave evidence, my client's brother gave evidence, a solicitor was called on behalf of the husband, an accountant was called on behalf of the husband, he had 3 counsel, and he prosecuted that claim with vigour. But he lost it. And part of the outcome of having lost that application was that substantial costs orders were made against him. So that at the time of the financial remedy proceedings, he owed my client a little short of £1 million in costs. So let me then move on to what happened after the preliminary issue proceedings. And I'll do that by dealing, if I may, first with the medical evidence. There is, if I may say so, an elephant in this courtroom, which is that the husband's absence from trial, without explanation, means that if it's found that he failed to turn up at the trial of his own application without good reason, he does not get to complain about the judge's findings unless they were clearly perverse, or get to ask for a retrial. And so let me take a brief but obvious example. The court found that my client does not hold a beneficial interest in the shares in the group of companies owned beneficially by her father and her brother. And my lord asked at the beginning, could the judge not have simply said, I'm just going to deal with this matter on the papers? And of course he could have done, but he didn't. He heard oral evidence from my client, from my client's brother, and from the SJE, whose absence we noted is complete from Mr. Xanthopoulos' skeleton. He doesn't even mention the SJE. And as a result of all that evidence, and I'm going to take you to it in due course, the judge found that my client does not beneficially own those shares. And there was ample evidence on which he could make that finding. And so any submission by my learned friend that suggests, well, I know she says that, but he simply is not allowed to make because the judge made findings in the trial. Could I ask you please to have a look in the transcript bundle first at page 243. And it's page 36 on page 243 at line 11, where I am addressing Sir Jonathan. And I say, even now, and I think this was at the end of the trial when I was making submissions, even now, we're all sitting here, including your lordship, wondering where is Mr. Xanthopoulos? What's he doing? Is he going to come back? When's he going to come back? One wonders how we could have ended up in this position. These were proceedings in which my client had paid £3.1 million in costs to Mr. Xanthopoulos, which he overspent by nearly £1 million, and he failed to turn up for his trial. And if you go back to page 241, you will find these perhaps prophetic words on page 27 at line 6. These were, again, my
Sorry,
submissions.
241,
241, it's page 27
Yeah.
of the transcript
yes.
at line 6. So she finds herself having handed over £3.1 million to Mr. Xanthopoulos, who has not appeared in court, but who may yet put his head above the parapet in another court, seeking to overturn whatever it is that your lordship may do in this case. And here we are. The husband's absence can be dealt with in 3 parts, 3 questions. Why did he not appear at the final hearing of this matter? 2, if his health had deteriorated so rapidly over the weekend after the refusal of his application for an adjournment, why did he not instruct his counsel, fully paid up? I'll remind you that they had spent just under £500,000 in the month or so prior to the trial without complying with a single direction of his lordship. Why did he not instruct them to make another application for an adjournment on the basis that he'd had another reversal in his health? And then thirdly, why did he not let his counsel or someone else tell the judge why he wasn't there and that he had no intention of coming for the duration of the trial? So can I deal with the first of those, please? Why did he not appear at the final hearing? And for our part, of course, the answer is that we don't know. What we do know, and it's relevant for your lordships and my lady to know, is that Mr. Xanthopoulos did not want Sir Jonathan Cohen to hear his case for financial remedy proceedings because he took the view that Sir Jonathan had an animus against him. And the papers are full of that fact. So if you have a look, please, at supplemental bundle at page 71. You will see an application that Mr. Xanthopoulos made on the 15th of March 2022 after the judgment in the Children Act proceedings, when Sir Jonathan found that the children were habitually resident in Russia, and he applied for the judge to recuse himself. And if you have a look, please, at page 72, you will see that he took the view that Sir Jonathan was not giving him a fair hearing. You see at the top of page 72, he refers to the judge's lack of partiality in his approach to the trial. He says, as is set out in the attached skeleton argument, in the judgments itself, and the way in which the judge approached within the judgment the resolution of the issues. The next line, he demonstrated an absence of fairness and balance. Next paragraph, regrettably, it's also submitted that an objective and fair-minded observer of the trial could have been left in no doubt that the judge was hostile to the husband. And then he goes down and he says there are numerous examples from the judgment itself. It's submitted on behalf of the husband. The judge made disparaging comments about him that could be sweeping and hyperbolic. So he refers in paragraph 1 to the judge saying that the husband seemed to be short of insight. Paragraph 2, the judge's judgment. I cannot see a shred of evidence to support his assertion that the school, this is the school in Russia, has manufactured or conspired with the mother to provide good grades for the older child. Paragraph 3, I do so against the background as I find of him seeing conspiracy around every corner. Paragraph 4, the father is a highly demanding client. And then in the penultimate paragraph, given the strength of concerns about the judge's erroneous analysis of the material issues and lack of partiality during the 9-day trial in the children proceedings, it's respectfully submitted that it's inappropriate for the judge to continue to determine any other matters between the parties, including in these Part 3 proceedings. So he applied for the judge to recuse himself. And he did not do that. But the husband persisted. If you turn on, please, to page 88. This was a hearing, a LASPO hearing, a funding hearing before Miss Justice Mostyn. And these are his rulings dated the 12th of April of last year on consequential matters. And you see in paragraph 2, he says, in his written submissions, Mr. Callum has been careful to circumscribe his submissions accordingly. In contrast, in an email sent on the 11th of April 2022, so the day before the matter was to be dealt with, as has been the husband's wont throughout these proceedings, the husband has sought to raise with the court and to include in the body of the order a shopping list, seeking directions about, and then B, filing a new or improved recusal application against Sir Jonathan Cohen with a new statement. And if I could then take you, please, to the husband's bundle at page 90. Seems to be sideways in my bundle, and I'm not sure whether in yours as well. And I'm going to have to read it out to you because you can see astonishingly in the middle of the page, the husband's reasons are set out in about font number 2. So they are unreadable to the naked eye.
Sorry, Mr. Stone, I was behind you. Which,
No, no.
Which bundle?
It's the
are you
husband's bundle, page 90. And you see in the middle of the page is the reasons which were given in an unreadable font, but we were able to enlarge them. And they say this, they say...
Is it the next day? Or?
The next
sorry,
page,
the next
no.
page.
The next page has got similar comments, but not the same.
Righty.
But they say a fair-minded observer would be troubled by the influence the respondent has on the allocated judge, combined with significant procedural irregularities and bias shown to the applicant by the allocated judge. So that was an application made in November of last year. Surprisingly, because as I will make clear from the medical evidence, it transpires he was in fact apparently in hospital at that time. And so Sir Jonathan Cohen remained the allocated judge, but found himself having to make further orders against Mr. Xanthopoulos, who, as Miss Justice Mostyn had noted, this is supplemental bundle, page 91. Said supplemental bundle. No, it's like the wrong thing. Paragraph 21. No, I'm sorry, that's the wrong reference. The judgment of Mr. Justice Mostyn. Give me a moment, it's on. I've got paragraph 21 of the judgment, which,
Is it the one beginning at 172?
yes,
Mhm.
but I think I may have a
It's
wrong
172
reference
is
here.
what's-
I'm going to
is-
come back to that. I'll find the right reference, but
It's at 177.
yes, I know that's the wrong reference. This is the judgment which has now gained currency in the family division, where Mr. Justice Mostyn referred in paragraph 3, which is on page 173, to the utter disregard for the relevant practice, guidance, procedure, and indeed orders as being totally unacceptable. He says, I struggle to understand the mentality of litigants and their advisors who still seem to think that guidance, procedure, and orders can be blithely ignored. And then he says on page 174, at the bottom of paragraph 3, it should be understood that the deliberate flouting of orders, guidance, and procedure is a form of forensic cheating and should be treated as such. Advisors should clearly understand that such non-compliance may well be regarded by the court as professional misconduct, leading to a report to their regulatory body. We also know, I think it's, I've got the reference, supplementary bundle, yes, the right page, supplementary bundle, next page, 174, that after the Children Act proceedings, where the judge made an order that the children were habitually resident in Russia, Mr. Xanthopoulos applied for funding for an appeal against the judgment. This is paragraph 7. These were the costs he was seeking. Future costs, small paragraph 1, £79,500 for an appeal hearing against the recent children judgment, and then 285,000 for a rehearing of the children proceedings. So in other words, exactly the same format as he has done in these proceedings applied to set aside and have a rehearing. And he also applied or wanted money to apply for, again, for the judge to recuse himself. So far as the medical evidence is concerned, the process was extraordinary. In October 2022, Mr. Xanthopoulos sent to the judge, through, I think, his friend Miss Gillard, although I have never, I think, seen the emails, some documents about his health. But he sent them to the judge on the basis that the judge was not permitted to disclose them. And he said that they were evidence of the fact that he could not appear in court in March 2023 because he had an operation booked. And he knows that the judge refused to look at that evidence until the 9th of February 2023, when the judge, in fact, saw what that evidence was, and I will take you to it in a moment. We also know that at the end of February 2023, if you could turn in the core bundle, page 174, when he saw Dr. Miners-Wallace, I think the date was something like the 24th of February. And if you look at paragraph 511, he told him that Mr. Xanthopoulos told him the nature of his intended operation and that he was waiting to have an operation. And this is the operation that he had told the judge he was due to have in March 2023 so that he could not attend the trial. So, if the question is why did he not appear at the hearing, one possibility, we don't know, is that he in fact went and had that operation. We simply don't know. I'm going to show you the documents about it in a minute. But we don't know because he hasn't filed any evidence about it. But it could explain, it's only, I can't do anything more than guess why his counsel felt that they were compromised at the beginning of the trial. But it is one possibility along with all the others as to why he wasn't there. Why then, second question, did he not instruct his counsel to make another application for an adjournment? Well, we know as counsel that we have two functions. One is to advise our clients and the second is to follow their instructions. And if we cannot follow them because they breach our code of conduct, then we have to withdraw. And we know that his counsel were not wholly without instructions because they said so. So if you have a look, please, in the transcript bundle at page 5, you will see how these proceedings started. Miss Hillas saying to Sir Jonathan Cohen, looking at the third line down now on page 5, it would not be right to tell the court that we are completely without instructions. However, such instructions as we have received means that we, I say the royal we, the whole team, my junior and I, and Miles Preston, are unable to discharge our professional obligations to the court. Sadly, and as a consequence of that, and having checked our professional duties very carefully with the appropriate bodies, my junior and I sadly have no choice but to withdraw. Those who instruct me, Miles Preston, are also in the same position, and they, through me, make an application in the face of the court to come off the court record. And Sir Jonathan said, does your client know you're going to be making that application? Ms. Hallas says, he's aware of where our professional obligation had left us, so yes, my lord. Sir Jonathan, is the situation remediable if he was to turn up at 2 o'clock? Ms. Hallas, well, my lord, clearly it's very difficult in terms of client confidentiality. What I can say is this, the court has seen the form H1, so the court will see the work that's been done. And we do know, because we did have an H1 and because Miss Hillas said so, that she had prepared a position document for the trial. But what she told me directly was not that she didn't have instructions to file it, but that she had instructions not to file it. And this is what does not make sense. A further application for an adjournment on the first day of the trial, based on an apparent collapse of the husband's health over the weekend, even since the application of the 9th of March, would not have caused professional embarrassment. On the contrary, there would be nothing embarrassing in saying last week the court refused my client's application for an adjournment on medical grounds, but since then his health has deteriorated to such an extent he's now in hospital in Greece suffering from whatever it is and providing medical evidence. But as you will see from the documents which you have said you'll look at de bene esse, and I'm fine about that, he wasn't in hospital. So the third question then is, why did he not let his counsel tell the judge or get someone else to tell the judge, a member of his family, a friend, why he wasn't there and he had no intention of turning up? We now know with hindsight now that he didn't turn up throughout the trial. And indeed, he went completely to ground until the 18th of April. But during the trial, we turned up at court every day, wondering whether he might turn up without warning as a litigant in person, as he had in fact done on the 19th of January, after several months of complete silence.
Just before we leave the page you've taken us to, Ms. Hillas said, what I can say is this, the court has seen the Form H1. Sir Jonathan said he was slightly confused by it. Have we got it?
I don't think it's in these bundles, although it may be, I need to check.
What did it say?
It said that the costs that they had expended It said the figure was approximately £650,000.
Right.
Sir Jonathan had made an order for legal funding of, I think, £653,000 up to the end of the trial. And £453,000 had been paid already, plus another £40,000.
So,
From previously.
forgive me, it was simply a statement of the costs incurred.
But it transpired that that did go up to the end of the trial, and they accepted that there would be some money not paid because they were not going to appear.
Sorry, Mr. Yes, you were saying he might have turned up at any point during
Yes.
the trial. In fact, he didn't. Yes.
It's clear from what I've read out to you already, they were not wholly without instructions. Simply they had instructions which caused them professional embarrassment. And if, again, he had been so ill that he couldn't even relay the information, that he was unable to come to court, well, then there were other steps that his lawyers could have taken which would not have caused professional embarrassment, but they did not. But could I take you then, please, to the core bundle, page 33. Which is his skeleton. And he says, in an astonishing paragraph, which appears, I'm afraid, to be giving his counsel giving evidence on his behalf, paragraph 48. Husband's mental and physical health did deteriorate to the extent he was not in a position to give proper instructions to his legal team. His family came to England over the weekend of the 11th to 12th of March to take him back to Greece, as they were concerned he would self-harm. He was seen by a doctor in Greece on the 16th of March during the trial. I'm going to show you that evidence. See the medical report of Dimitris Agorgianitis of that date, who noted there was a worsening of his psychopathological symptoms and a compromise of depressed mood and anxiety, mild self-destructive ideation. His health remained unstable, and husband reported being in a state of real distress. I pause to ask, reported to who? His hospital discharge certificate of the 4th of April, after the trial was over, I'm going to come back to that, reflects that he was admitted as an inpatient to a cardiology unit in Greece on the 1st of April to the 4th of April due to supraventricular tachycardia, with reason given as psychotic syndrome. So this is after the trial is over, and he was told to avoid emotional load. There is not an iota of evidence of his travelling to Greece, even by way of an airline ticket, for him or any member of his family over that weekend. Second point, he had dissembled in the past, the recent past, on the 3rd of October 2022, about being in Greece. There was a hearing on the 3rd of October and the husband was due to attend. I'm going to come back to that, but the short point is his counsel said he needed to appear by video link because he had, I think, stomach-related problems. We all sat in court. He said, I can't get my video on. I can hear, though, it's fine. And my client gave instructions and said, well, I find this very odd because on Saturday, he was speaking to our daughter from the beach in Athens. And Sir Jonathan said to him, are you in Greece? And he said, yes, I am, actually. So he hadn't told the court, but he was, in fact, already in Greece. On the 9th of March, which was the hearing that was supposed to be for the injunction, but that, as Sir Jonathan said, got hijacked by Mr. Xanthopoulos. He wasn't there. Who knows if he was already in Greece? We don't. He said he wasn't, but we don't. And on the 15th of March, the first day that we were in court, Sir Jonathan asked whether he was in fact in Greece, and they felt unable to answer. And if you look in the transcript bundle, that's on page 13. you will see if we start at B, I said, fourth line down, I do think your lordship's entitled to know whether he's in the country, bearing in mind he has been ordered to attend these proceedings. Jonathan, yes. Said to Miss Hillas, I think I'd like to know when you were last in communication with him, you or Mr. Durl. My lord can probably see my face, says Miss Hillas. I'm just very concerned about my professional obligations to Mr. Xanthopoulos in terms of client confidentiality. And then she says, just above letter E, there have been exchanges of emails. My instructing solicitor confirmed to Mr. Xanthopoulos this morning that the hearing was starting at 10:30. I can tell the court that. I think I'm under a duty to tell the court that. Beyond that, my lord, I don't think I can assist any further. And then Sir Jonathan says, I think I can ask you when you last received a communication from Mr. Xanthopoulos. And she says, it would have been yesterday, my lord. It was midday-ish, early afternoon. Mr. Xanthopoulos had been ordered, it's in the supplemental bundle at page 114. He had been ordered as part of a schedule of deficiencies to say, paragraph 27A, there were questions you will see there. I should tell you what date this order is. This is Sir Jonathan's order of the 14th of November. He had been ordered to answer certain questions in a schedule of deficiency that had been served on him. And I can give you the reference without turning it up, but in the core bundle 243, question 25O, which he had been ordered to answer, was to give details of all the dates since, I think, 2015, when he had been in Greece. And he never answered that. So can I take you then to the medical evidence? And I'll try and do it as quickly as I can. There's an extraordinary fact here that over 3,000 pages have been filed in this appeal. And apart from the report of Dr. Miners-Wallace, which we will look at, the total number of pages dealing with Mr. Xanthopoulos' health prior to the hearing were eight pages. We're going to look at them. They're in the supplemental bundle, pages 260 to 267. And after the hearing, 6 pages. And they are in the further evidence bundle at pages 15 to 20. And the medical evidence, such as it is, falls so far short of explaining why he was not at court that the court should allow him no leeway. And this, we say, is the crux of this appeal, or at least the very largest part of it. Because if you do not turn up at court on your own application without giving any sufficient reason, you do not get to ask the Court of Appeal to set aside proceedings which have cost my client millions upon millions upon millions of pounds. I think the total figure was about 8.7 million, to which you can now add £500,000 for this appeal, so that you can have another go in front of another judge at a cost of further millions upon millions. Nor to run your arguments on the facts in the Court of Appeal if your position on the facts differ from those of the trial judge. And I'm just going to remind you of the figure, £483,000 spent by him in the month before the trial without complying with a single direction.
Now, Ms. Stone, when would be a convenient moment to break off? Would you like to finish the medical reports, or is that best left till tomorrow?
If I can finish it in the next 10 minutes, I think that would be good. I'm happy to leave bits of it out.
All right.
I'll go on for 10 minutes, and if
Yes,
I don't
but
get
then
there. I'm going to take the first bit quickly. I've explained to you what happened at the hearing on the 3rd of October. His counsel, I'm sorry, I made a mistake. It wasn't stomach problems. He said his client had a chest infection and was on antibiotics. And on the 3rd of October, because the timing of the trial had been derailed by the preliminary issue proceedings, the judge, in fact, stood out the trial, which was due to be heard in December. And he said it was to be listed on a date to be agreed at the beginning of the year. And we couldn't agree a date, and so the judge listed it, the case, for the 20th of October for a fixing hearing. On the 4th of October, the husband issued the application, which I've shown you just now, the one with the tiny writing, and said that he was in hospital and he wanted the application for March adjourned on medical grounds, but he did not produce any medical evidence. And the judge, at the directions hearing on the 14th of November, made directions, it's in the supplemental bundle at page 111, permitting the husband even to make an application over Christmas on short notice if necessary, to explain what the issues were in relation to his health. The next hearing was the 19th of January, when, as I've told you, Mr. Xanthopoulos turned up in person with Miss Gillard. He was, as the judge found and included in his order, coherent, and he addressed the court at great length. And he said that there was medical evidence he wanted to put before the court, but he wasn't in a position to do it yet, or even to tell the judge what that medical evidence was. And the judge listed the case again for a directions hearing on the 9th of February, and he made a very generous as per order to make sure that the husband could be represented by yet another firm on the 9th of February. And he said to the husband, all in the orders, page 122 of the supplemental bundle, that any lawyers who turned up on the 9th of February must be told that there was a hearing in March. And he turned up on the 9th of February with leading and junior counsel and solicitors. And his first application was to adjourn the hearing in March on the basis that the lawyers who were in court were not available for the March hearing. And there was then a debate between Mr. Howard, who then appeared on behalf of the husband, and the judge as to whether or not the judge would be entitled to look at the medical evidence. And Mr. Xanthopoulos again insisted that if the judge was going to look at it, it could not be shown to Miss Rakshina. And the judge said, yet again, I will not look at medical documents and be restricted in what I can do with them. And the debate ping-ponged backwards and forwards, and eventually, after taking instructions from him, I should say Mr. Xanthopoulos was not in court, he was in Greece. He said he was staying there at a flat. First of all, he called it my flat, and then he said it was the flat of his friend Christina, but he wouldn't say anything else about it. He allowed the judge to see those documents, but he, in fact, said to the judge, I am ordering you, Mr. Xanthopoulos said, to say that these documents cannot be shown to Miss Rakshina's Russian lawyers. And Mr. Howard made clear to the judge he was not saying that there was any issue about his client's capacity. He said he was due to have an operation in March, and he had been an inpatient for an unrelated matter. And he said, in due course, on instructions, that he wanted the judge to look at his medical documents. I think I can take you really probably even in 5 minutes, just to those medical documents, to show you how very brief they were. In the supplemental bundle, first of all, on page 260. There was a document. It's a translation. We didn't get the original, by somebody who says he's a psychiatrist. We knew nothing about his qualifications. It's a few lines long. It's not compliant in any way with the rules for evidential purposes. It was dated in October, 5th of October, so it was several months old by the time it was disclosed. But it said that he had first had symptoms 6 months before that, so towards the beginning of 2022, but since which time, in fact, as we knew, he had participated fully in the preliminary issue proceedings. And the report said at the bottom, penultimate lines, it is considered appropriate to stay out of work for 30 days.
Yes.
So it appeared to be in the nature of a medical certificate, no certificate of independence or anything of that nature. And then there was another document, also dated the 10th of October, also in Greece, saying that he had been examined and he needed an operation, and that will be operated as initially planned on the 21st of March. That's the bottom of that document. I'm not going to say in each case about the evidential lack of compliance, but you can take that as read. There is then a document at page 262, which appears to show that he had been admitted to hospital under what was effectively a section on the 16th of October. And you will see on page 262 there is reference to a suicide attempt, drug-induced self-destructive attempts, alcohol abuse, and you see at 5, duration of current episode in the last 1 month, total duration of the disorder, about 2 years. And he was hospitalised on an involuntary basis. And then you'll see at point 12, I don't know what it is, under 11, under 1C, 2, I think, the hospitalisation is necessary to prevent acts of violence against himself or third parties. And when Sir Jonathan saw this, he felt it was imperative that this was disclosed to the Russian court, because Mr. Xanthopoulos, at the same time as he was asking to have the proceedings in England adjourned, was proceeding in Russia to ask for, I think, what was effectively a joint custody order of the children. You will see on page 264 a discharge certificate. Under patient's details, you'll see it's got a home address. That was blacked out on the version that we were shown at court. This is a property in a very upmarket area of Greece. There is then on page 265 a certificate of hospitalisation with the drugs which he was prescribed in leaving, and then 266, a one-page report dated the 13th of December. According to the patient's records kept in our office, we were not given any records. He'd been hospitalised from the 16th of October to the 18th of November. Medication, regular psychiatric monitoring and psychotherapy are recommended, and an assessment was performed. And then the last document I'm going to ask you to look at, actually I might leave that till tomorrow because it ties up with what you need to look at for the post-hearing documentation, but that's where I'll start tomorrow on page 267.
Right. Thank you very much. Stay in. 10:30 tomorrow.